Next, we will hear from Rahul Rao. Rahul serves as the Deputy Director of the Federal Trade Commission's Bureau of Competition. Rahul oversees a team of 300 attorneys and support staff that uphold federal antitrust laws. As the Deputy Director, he assists the FTC with conducting merger reviews, anti-competitive conduct investigations, and antitrust litigation. Rahul regularly testifies before Congress and speaks at panels and workshops. And we're so honored to have him with us today to help us understand the FTC's role.
Well, thank you, Catherine. Can you hear me okay? I just want to make sure. Well, thank you, Catherine. Thanks for inviting me here. I want to start with just a simple disclaimer. I want to note that I am speaking on behalf of myself and not the Federal Trade Commission. My comments today don't necessarily reflect the views of the commissioner or any individual commissioner. So we have a really interesting discussion today on hospital consolidation. Now, consolidation as a general matter is happening across the country in all sorts of industries. Too often we are seeing companies not necessarily focused on improving their products or bettering their services, but rather focused on getting bigger for the sake of getting bigger, because the bigger they are, the more they can crowd out or outmuscle the competition, and the easier it is for them to raise rates, cut corners, or simply do whatever they need to do to eke out a little bit more profit. Now, as I said, this is happening across all industries, across the country, and antitrust enforcers are focused on harm in all markets. But healthcare is unique and healthcare is different. In healthcare, we are quite literally dealing with life and death stakes. So for us, healthcare markets are some of the most important markets for us to protect. In the US federal system, we have two antitrust law enforcers who review mergers, the FTC and the Department of Justice. Our jurisdictions overlap and we enforce mostly the same laws, but it's the FTC that traditionally handles most healthcare provider mergers. The principal statute that applies to mergers is the Clayton Act. Section 7 of that law prohibits mergers that may substantially lessen competition or tend to create a monopoly. The focus on competition is our North Star when we review mergers. And so what do we mean when we say competition? I mean, simply, it's the rivalry that exists among firms that engage in any form of economic activity. That rivalry can be motivated by a desire to sell a product or a service, to buy a product or a service, or to hire the best workers. Competition, to sell, to buy, to hire, it has many benefits. When companies compete to win customers or patients, they're motivated to offer lower prices, better quality, better services. They're motivated to innovate new and improved products. Similarly, when they compete to hire workers like nurses, they're motivated to offer higher wages, better benefits, and improved working conditions. We focus on competition when we review mergers because there is real harm if a merger eliminates an important source of rivalry in a marketplace and thus reduces the motivation to offer better prices, wages, or products or services. Now, there are many different types of transactions that can raise concerns. I'm going to highlight two really broadly applicable fact patterns, but it's not an exhaustive list. The first, and I think the one that most people are familiar with, are mergers between head-to-head competitors. These types of mergers can raise alarm bells for antitrust enforcers, particularly when they are significant competitors in a particular area, and especially when there are few alternatives to the merging firms. One straightforward way that agencies and courts evaluate this is by looking at metrics for market shares and market concentration. Put simply, if the merger results in a firm or a hospital system having significant market share and there are few remaining competitors, or if the remaining competitors are pretty insignificant, that's going to draw our scrutiny. We're also concerned about other types of transactions. You may be familiar with so-called vertical mergers. These transactions involve parties that don't offer the same goods or services. Rather, one merging party offers something that the other merging party uses in their business. So a really simple example is a car manufacturer uses steel to build cars. If a car company buys a steel producer, that's a vertical transaction. In the healthcare context, a vertical transaction could be something like a hospital system purchasing medical groups or an insurance company acquiring a provider. While the merging parties themselves aren't direct rivals and insurance companies not competing with the provider group, vertical mergers can also harm competition. Going back to the insurer example, if a large insurer buys a major medical group in a specific community, it can charge rival insurers higher prices for the medical group services, or may prevent rival insurers from contracting with the medical group altogether. This in turn may force rival insurers to charge higher prices or to offer inferior health plans or to exit the market entirely. Now, those are just two species of mergers that may be problematic, but regardless of the type of merger, whether it's horizontal, whether it's vertical, or whether it's some other orientation, when we evaluate any transaction, our focus is really on what the law prevents, which are transactions that may substantially lessen competition or tend to create a monopoly. Now, how we evaluate that is both a backward and forward-looking exercise. When we do merger review, we're necessarily making predictions about the future effects of a merger, but we don't do that in a vacuum. We look to see how the merging parties compete in the marketplace today and ask how the merger will change their incentives or their ability to compete. And here, past is often really prologue. The fact that merging parties compete strongly with each other is a strong indicator that the merger will substantially lessen competition. So when we investigate a merger in the healthcare industry, let's say between two hospitals, we ask ourselves a series of questions. Are the merging hospitals important alternatives for patients? What other options are available to patients? Are there other hospitals that are equally attractive for patients? Would patients be willing or likely to turn to other hospitals if they're not happy after the merger? Are the merging hospitals competing to attract patients through improved quality, developing new service lines, adopting new technology, increasing access, or making capital investments to increase capacity? And would the merged hospital system have the same motivation to undertake those efforts after the merger? And also after the merger, will the hospital have a significant market share? And if so, will they be able to demand higher rates from health insurers? Would insurers have to accept those rates because the newly merged system is too important to exclude from their network? Those are some of the questions we ask. And oftentimes, to rebut the answers to those questions, merging hospitals will often claim that their merger will have some significant benefits. When faced with these claims of supposed benefits, we ask, what evidence is there? What evidence is there that the benefits will actually occur? Are the benefits speculative? And could those benefits be achieved through some other way that does not involve a merger that eliminates a competitor? And you heard me mention this before, we also look at a merger's effect on workers. And here the questions we ask are fundamentally the same. Are the merging parties important alternatives for workers like nurses? Are they competing to attract those workers with better wages, better benefits, or better working conditions? And what are the other options available to those workers? How similar are the other potential employers? What's the geographic radius that these workers are willing to travel for a different job? Ultimately, is the competition for these workers important enough that they would be substantially worse off after the merger? Now, reviewing mergers is a critical part of our authority, but our principal enforcement power is our ability to sue to block or unwind mergers. So after an investigation, if we believe that a merger is anti-competitive, we file a lawsuit before a federal district court or an administrative law judge to challenge the legality of the merger. And we don't always do this alone. We frequently work closely with state attorneys general, especially in the healthcare context. Healthcare is inherently local and central to our communities. So working with our state law enforcement partners is something we value when it's possible. And so you will often see state AGs join our lawsuits to block a hospital merger. Now, talking about our lawsuit, you heard Zach mention this in the past session. For the past 2 decades, the FTC has a pretty solid track record on challenging hospital mergers. We've challenged about 12.5 hospital mergers in the past 20 years and only lost one. We've developed a very successful playbook for analyzing and challenging mergers involving hospitals that are head-to-head competitors. And that statistic I just mentioned, it does not include hospitals that have abandoned mergers after we've begun our review. It does not include mergers that state AGs were able to block using the playbook we put together on how to evaluate hospital mergers, nor does it include proposed hospital mergers that never made it out of the boardroom. But, and you did hear Zach mention this, despite all these wins we've had in court and all the progress we've made, we're still seeing rampant and concerning levels of concentration in healthcare markets. So our task in the enforcement community now is to identify these other drivers of consolidation and come up with the right analytical framework to understand and successfully challenge them. And there are a few drivers of consolidation beyond the traditional local hospital merger that we are seeing today and that we are scrutinizing. The first is on non-reportable deals. These are deals that fall below that HSR reporting threshold that Zach was mentioned. The current threshold is $111 million. So these deals are hard to detect since the parties don't have to tell us about them. But just because they're small, and by small I mean less than $111 million, that doesn't mean that these deals can't have significant impacts on their communities. And there are two different types of non-reportable deals that I want to focus on. The first is on what we call roll-ups. Now, traditionally, when we review a merger, we look at the single transaction that is being proposed. A roll-up, however, is a series of small acquisitions that, in isolation, any one of those transactions may not look concerning, but taken as a whole, the series of transactions lead to a quiet accumulation of concerningly high levels of market power. In the healthcare context, what we are seeing are health systems and private equity firms acquiring small independent medical practice through a series of acquisitions, a 30-person group here, a 5-person group there. Small acquisitions like this done over several years. Each acquisition, again, when viewed alone, may seem insignificant. And the FTC may not even find out about these transactions because they're so small and fly under the radar. But over time, those little acquisitions add up, and they can lead to highly concentrated markets where one health system or one provider group employs a significant number of physicians. And while the roll-ups are hard to detect, their effects can be very acute. We recently filed a lawsuit challenging a roll-up in the healthcare space. That suit was filed in Texas, challenging a roll-up in the anesthesia market by a national practice and its private equity sponsor. As the complaint alleges, the defendants in that case quietly acquired a number of small anesthesia practices in various cities in Texas, eventually amassing a dominant market share in those cities and using that market power to extract higher rates in those communities and throughout Texas as a whole. So another concern, that was one concern we have with sub-HSR transactions. Another concern with sub-HSR transactions is on what I want to describe as identifying and preventing catalyzing events. So when I say catalyzing events, what I mean is a transaction that serves as a flashpoint for a downward spiral towards consolidation. This is about stopping the snowball at the top of the mountain from ever becoming the avalanche. So an example of what I mean by this, in past merger reviews, we've seen situations of a proposed merger in a highly concentrated market, markets where there are 3 hospital systems and 2 of them want to merge. Under a straight legal and economic analysis, these mergers are highly problematic and illegal. The problem we face with some of these mergers is that the B side, the hospital that is being bought, is oftentimes a very distressed asset. It's a system that may be on the verge of bankruptcy and of shutting down. So blocking a merger does not always help the community. Concentration will increase whether the hospital is bought or whether it shuts down in bankruptcy. So the problem is by the time it gets to us, it's sometimes too late. Now, some of the things that we've seen when we're reviewing these mergers that fall into this fact pattern is that at some point, years before, one of the 3 systems, usually not the one that is currently in financial dire straits, but one of the systems engaged in a large but sub-HSR transaction, often a large provider group acquisition. And it was this transaction that started the downward spiral towards consolidation that culminated in a near bankrupt hospital and in a market with 2 to 3 hospitals in it. That group acquisition from years ago, that was the snowball at the top of the mountain. So part of our task here is to build out an early detection system to identify these smaller transactions and stop them before they lead to irreversibly concentrated markets. And there are things that we can do on this. You know, Zach said we need more funding. I will not say no to that. First, I hope Congress will give us more resources so that we can pursue more cases preemptively. Second, our partners at the state level, they have much more visibility and activity of the activity in their community. And they also have different laws on reporting healthcare transactions. So our state partners can and often do alert us to problematic acquisitions that don't rise to the HSR reporting level. And third, we encourage any knowledgeable market participants to flag transactions for us in real time. Now, these sub-HSR transactions, they're one issue, but we're also faced with kind of the opposite issue. We are also faced with mega mergers in healthcare. And as a general matter, the commission finds out about these mergers before they're consummated because they're very big. And we do our best to investigate and challenge these troubling mega mergers. One challenge, though, is that two large hospital systems that are trying to merge may not actually have facilities in overlapping geographic markets and thus may not compete for the same patients. Some of the antitrust community have referred to these as cross-market mergers, and as you heard, that name may not be fully accurate. Now, if the merging parties don't actually compete at all in any capacity, then there are paths to blocking the merger are limited. But the problem here is that in the wake of these mega mergers or these so-called cross-market mergers, we see the undeniable effects of lost competition. We see rates go up, we see quality decrease, and we see services cut. So when we look at the effects of the merger, we know there is some loss of competition that's driving those effects, even when the merging hospitals aren't directly competing for the same patients. So what is that lost competition? It could be a dominant statewide employer or a payer trying to provide a health plan to all of its statewide employees or insurance enrollees, or it could be something else. So our task here is to better understand what's happening, to understand and identify all the dimensions of competition and the full extent of the commercial realities, not just the ones centered on local geographic area, so that we can prospectively analyze a so-called cross-market merger and block it before it results in harm. Now, another thing you've heard me mention is a focus on workers. Hospitals tend to be one of the largest employers in a community. And so we don't want to lose sight of any effects a merger may have on those who work at hospitals, for example, nurses. These are our unsung heroes in healthcare, and we want to make sure that a merger doesn't create a dominant employer that has the power to lower wages, lower benefits, or other working conditions. And it's obviously worth noting that overworked and underpaid hospital staff also have a direct impact on the quality of patient care. So making sure that our critical workers like nurses are protected and taken care of is important for them, but it's also important for patients. So evaluating labor impacts is a critical part of our hospital merger review. Now, I know I'm running a little past time and I want to just quickly wrap up. There are some other process developments in the pipeline that we also hope will help us combat consolidation in healthcare markets. The first is that the FTC and DOJ are revising our so-called merger guidelines. By way of background, the FTC and DOJ put out these guidelines that describe the analytical framework and the tools we use to evaluate mergers. The merger guidelines provide guidance to the public, to merging parties, and to the courts on how to assess the legality of mergers. And while they're not a law, they don't bind courts or judges. Judges do typically find them useful and have traditionally adopted their framework when litigating merger challenges. So we are in the process of revising our merger guidelines, which were last updated in 2010, to better reflect how we assess mergers today. The revised guidelines will provide more clarity on many of the issues we touched upon today, including evaluating the effects on workers, better articulating what the concentration thresholds are for a merger that's presumptively legal and things like that. And we also proposed a revision to the form and the information that parties have to submit to the FTC and DOJ as part of their HSR filing. The goal here is for the agencies to get more of the critical information up front so that we can evaluate a merger early, and so we can more effectively assess and screen those mergers that raise concerns and not waste time reviewing mergers that are not problematic. And basically where I just want to leave it is that there's clearly a concerning trend towards consolidation and concentration in healthcare markets, and the FTC is committed to doing everything in our power to combat this trend. So thank you for the time.
Thank you so much, Rahul, for helping us understand all the efforts going on at the FTC to address consolidation. Next, we will move